Hello, voice. Voice आ रही? Voice. Hello. Shall we start? So, okay, students. Now we will continue our lecture on Article 21. 21, as we have already studied, is right to life and personal liberty. That is one of the mammoth, a very big fundamental right which practically covers all the aspects of the fundamental right in the scheme of part 3rd of the Constitution. Right to life and personal liberty. So, we have already seen the development of this right, which was practically dormant for about 3 decades, starting from the inception of the Constitution till 1978, when the Maneka Gandhi case happened. And this article came into question in A.K. Gopalan versus State of Madras case. In A.K. Gopalan versus State of Madras case in 1955, what actually happened was that they delinked Article 14, 19 and 21. In A.K. Gopalan case, the judges said that Article 14, 19 and 21 are mutually exclusive along with Article 22 also. A.K. Gopalan was the opposition leader who was booked in preventive detention. So this judgment was all about preventive detention. What is preventive detention? That if a person who can cause disturbance or public order, even if he has not done anything now, can be booked, can be sent to jail just on the presumption that he can cause the public order in future. That is preventive detention. Now the state has the power, and state also has the duty and responsibility to keep the public order. In order to make the citizens safe, if some person who can create nuisances, a person who can be of some danger to the society can be detained. That is what is preventive detention. But this person, this was a political detention. He was an opposition leader, and the opposition party at that time was very minor. So the ruling party has confined him into jail by preventive detention clause. What ended up happening is that A.K. Gopalan went to the Supreme Court and said that his Article 21, life and personal liberty, has been infringed. Also, several provisions of Article 19, such as right for movement, has been infringed. But then court said that whatever procedure which has been developed or established by law has to be followed. And what was the procedure which was established by law? It was simple, a preventive detention clause, and according to that preventive detention clause, A.K. Gopalan was sent to jail. Now, court has refused to see whether this procedure which was established by law was due, was just, proper or not. That is the reason procedure established by law is one of the cornerstone of Indian Constitution, but not due process. This was the position till A.K. Gopalan case was prevalent. After Maneka Gandhi case, this position has changed. The magic which came after Maneka Gandhi case, the one most important thing which has happened was the reinterpretation of Article 21, which has included due process of law, the procedural due process, into the procedure established by law. So after Maneka Gandhi case, what happens is, under Article 21, you can take, the state can take the life and liberty of a person if it is according to the procedure established by law. No right is absolute. In several circumstances, the personal liberty of the citizen can also be taken away. This article 21 applies to citizens and non-citizens both. So, of course, several circumstances comes in the life of a country where the personal liberty of the person can be taken away for the interest of the country, for the interest of the public at large. But there has to be some procedure which is established by law. It cannot be arbitrary. It cannot be on the whims and fancies of the administration, whims and fancies of the legislature. Parliament has to play a role. It has to pass a law, and only according to that law the personal liberty and life of a person can be taken away. But that was it. It was nowhere written in the Indian Constitution that the procedure has to be due. The word due, due process. What does this word due means? It means it has to be just, it has to be proper, and it has to be reasonable. Just, proper and reasonable. So, Article 21 did not include the word due process, procedural due process, and because of that A.K. Gopalan's sentence, A.K. Gopalan's preventive detention was declared as all right. It was not declared as null and void, but it was all right. It was because it was according to the procedure established by law. The law says so and it has been done. But the Supreme Court will not venture into the due process, whether the law was just, proper or reasonable. The law may be arbitrary, but still whatever the law says will be allowed. This position has been changed after the Maneka Gandhi case, where the reinterpretation of the phrase procedure established by law appeared. And what was the reinterpretation? That the procedure established by law includes due process of law. So, in a way, the American concept of due process of law was included in the Indian Constitution by the interpretation of the Supreme Court in Maneka Gandhi case. What happened in Maneka Gandhi case? Very simple. Her passport was impounded. According to the Passport Act, there is several sections in this act, and section 10(3) clause number 3 subclause C says that government can impound your passport on the basis that it may cause public disorder, it may cause it may hurt the sovereignty and integrity of the nation, and the relation with the friendly state may get hurt. So, because of that your passport can be impounded. So, Maneka Gandhi was travelling abroad and her passport was impounded by the government. So, she was unable to go abroad, and that is why she ended up in Supreme Court under Article 32, saying that my personal liberty to go abroad has been infringed. Now, Supreme Court's judgment has changed the whole philosophy of Article 21, and in this judgment Supreme Court interpreted that Article 14, 19 and 21 are not mutually exclusive but are linked. They are complementary to each other. Article 14 is about right to equality. If the state snatches somebody's equality, then it has to be reasonable. Under Article 19, if any of the fundamental right to freedom has been infringed, then again there has to be restrictions which are reasonable. So, in both these articles, if you see Article 14 and Article 19, the restrictions which are imposed by the state are the reasonable restriction. when they contain some reason, they are just, they have to be proper, and state cannot infringe any of these fundamental rights 14 or 19 without the reasonable restrictions being in place. If the restriction or the limitation on the right is not just, proper or reasonable, then the state cannot infringe anybody's fundamental right of freedom and of equality. The same principle was not applied to Article 21 before the Menaka Gandhi case, but since Menaka Gandhi case, when these three articles were linked by the Supreme Court, and it has been said that they are not separate islands but a whole one combined land which is not mutually exclusive to each other but are independent on each other, dependent on each other, and because of this dependency, the reasonable restrictions which are imposed in Article 14 and Article 19 has also to be applied to Article 21. That if your life and if your liberty is harmed by the state for whatever reason, then that reason has to be just, proper and reasonable. So, in a way, substantive and procedural aspect of Article 21 was reinterpreted, and reasonableness, proper and justness was introduced. That simply means due process of law was introduced in the Indian Constitution after the Menaka Gandhi case, after Article 21 was reinterpreted. I hope you have understood the whole story. Now, let us come to three very important terminologies of Article 21. What do you mean by life? What does life means in Article 21? Protection of life and personal liberty. What does the word life means? Life means existence. Life means existence. You are living, you can walk, talk, eat, whatever you want to do, you can do. That is what existence means. That is what life means. But to live a life with dignity, that is what one person aspires. And when you read Article 21 and how the Supreme Court has interpreted it, it is not only animal existence, but for human being to grow to its optimum limit, this existence has to be what? This existence must have a dignified existence, must be a dignified existence. Dignified. So, life must contain dignity. That is what is Article 21. That is what the word life in Article 21 means. It's not only the animal existence. This is not the only meaning of existence, that you are living, now you are sleeping on the pavement with no education, no clean air, no food at all. That's not existence. You need to have good proper education, you need to have good proper health care facilities, your children must go to schools, the youth must have employment, skill development program should run, or else from where the youth will earn, and without earning you cannot have a dignified life. At the same time, when you are living, you also need clean water, you also need clean air. The women who are going to the workplace needs protection. You also need privacy in your life, that your name has been published by newspaper for whatever right or the wrong reasons, that hurts your right to privacy, which is inherent in the word liberty and also life. So, when you talk about dignified life, the contours of Article 21 stretches to maximum limits. So court on one hand was reinterpreting Article 21 and saying that life does not only mean animal existence, but is way more than what life actually means. It is the dignified life, a life which a person, if not proud of, is at least happy to live. So that is what is called dignified life. So on one hand, Supreme Court was interpreting the different terminologies of Article 21, life, liberty, law, procedure, and on the other hand, the Supreme Court is saying that they have to be just, they have to, all the restrictions have to be proper, all the restrictions have to be reasonable. So this is what life means here. What does liberty means? Do you have the liberty to go abroad? That was one of the basic fundamental question which was raised in Maneka Gandhi case. You have the right, you have the freedom to reside in India wherever you want. That is the freedom given under Article 19, 1E. Also 19, 1D talks about freedom of movement. So this freedom of movement is within the country. What about movement outside the country? What about going abroad? That is covered under Article 21. So Article 19 tells about several specific freedoms. Several specific freedoms, such as you can form associations, you can form assemblies, you can protest, then you can move anywhere in the territory of India, you can reside anywhere, you have the right to choose any profession. Also you have the right to freedom of speech and expression. Those are the specific areas, but those freedoms, those liberties are not confined to Article 19 also, but there are many more when you talk about dignified life. And all the others which are not covered under Article 19 are then covered under Article 21. The word liberty is so broad. Liberty contains the religious liberty. Now go to the preamble and see liberty of thought, expression, belief, faith and worship. So liberty covers Article 19, liberty covers Article 14, liberty covers Article 22. Liberty also covers from article from 25 to 28, which is the religious rights given to the citizen of the country. So Article 21, the word liberty actually covers everything. That is why it has been called as the heart of fundamental right. Article 21 is the heart of the fundamental right, covers everything. If you do not have equality at the workplace, your liberty has been hurt. If you do not have freedom, again your liberty has been hurt. If a procedure which has been established to put you into jail on the clause of preventive detention is not reasonable, again your liberty has been hurt. So this liberty has a very wide connotation. Its amplitude is way too large, and several cases has came in front of Supreme Court where prisoners wanted to write books and read newspapers within the premises of the jail, and they were not allowed, but after the reinterpretation of Article 21 they were allowed. So Supreme Court said that it is from the both side, the liberty is not of only the person who is free, but also the person who is imprisoned enjoys life and liberty. He has been confined because he has done something wrong, and according to the procedure established by law, that confinement is reasonable. But at the same time, you cannot go on punishing him by taking away his liberty, such small liberty which is necessary for the human life to sustain, such as read, clean air to breathe. nice food to sustain his body within the jails. So liberty has very wide connotation here. Then the third thing comes up is law. What is law? Protection of life and liberty. Procedure established by law. So what is law? Enacted law. Earlier it was only seen as enacted law. Enacted laws are the laws which are made by the parliament. Now the question came up in front of Supreme Court whether ordinances can be considered as law or not. So the court has came up to the conclusion that ordinances will also be considered as law. This is ordinance is actually a step taken by the administration, by the executive. Although they have to confirm it with the legislative later on within 6 months, but still it is a step taken by the executive. So enacted law, in a sense, ordinance is not an enacted law because initially it is not passed by the parliament. The executive have the power to pass an ordinance when the parliament is not in session. So how can that be called an enacted law? That is not an enacted law until and unless the parliament approves that law within 6 months. Now if think about a situation where government comes up with an ordinance which hurts your life and personal liberty, and when you go to the court says that law only means enacted law, that ordinance has not been passed by the parliament. So you are giving arbitrary power in the hand of executive to take away your life and personal liberty. So that is why Supreme Court again reinterpreted and said that ordinance are also to be considered as law. So law are all kind of law. It can be enacted law and non-enacted law. Enacted and non-enacted. Remember Article 13 and the definition of law within it. Can be ordinances also. Then life, liberty, and then comes procedure. So whatever procedure which has been established by the law have to be just, have to be proper, have to be reasonable. It cannot be arbitrary. It cannot be arbitrary. This is must thing to remember. It cannot be unreasonable. It has to be reasonable. It has to be just and proper. It cannot be arbitrary. So that's what procedure means. So when you understand Article 21, these four things, life, liberty, law and procedure, has to be seen with a closer focus. Now, what impact has it brought? Maneka Gandhi judgment, what impact has it brought in the Indian administration and the constitution and the life of the people? If you see, after Maneka Gandhi case, Article 21 has been reinterpreted. Every single word in it we have seen, life, liberty, procedure, law, has been reinterpreted and its amplitude increased. Now, second thing which was reinterpreted is due process was introduced. Due process was introduced. The procedure established by law must also contain the due process. That simply means the law has to be just, proper and reasonable. So due process was also introduced. So it must have brought some changes in the Indian constitutional life. Yes, why not? 2 or 3 days back, there was a news in the newspaper which says that right against climate change has also been included in Article 21. Now, a right against climate change has been made a fundamental right under Article 21. So, the court says that the constitution mentions several fundamental rights. They are expressly mentioned. But that does not mean that the contours of fundamental right are limited to the expressed fundamental right. It can go over and beyond the expressed fundamental right, and with several interpretation of the word life, dignified life, liberty, procedure and law, it can be stretched to many more aspects of the human existence, and one of them is climate change. Another of them is noise pollution. Then environmental protection. Then Vishaka versus state of Rajasthan, Vishaka guidelines. About the women, the protection of women at the workplace, right to privacy, Puttaswamy, Justice Puttaswamy, retired versus Union of India, privacy, reputation, and many more. You can go on increasing this list. About hawkers, Supreme Court have said that the hawkers who stand on the road to sell their items, they have the fundamental right of freedom to profess any profession, to practice any profession, to choose any profession, but that does not mean that you take up public places for your private work. So the hawkers which are standing on the road and making it congested will not be allowed, or else they will be allowed only on the weekends, and the administration has to take up the issue and do whatever which is necessary for the maintenance of law and order. At the same time, it also speaks about rape. Rape, which is one of the most hated crime, and the dignity and the confidence of a woman reaches the lowest ebb, and sometimes the emotional pain is so much that it takes the whole lifetime to come out of it. What is happening in rape? Your life and personal liberty has been hurt very badly and brutally. So in such situation, you can approach the Supreme Court under Article 32 by saying that my fundamental right of life and personal liberty has been abridged. Article 21 was against state. If you see Article 14, Article 19 and Article 21, who has the onus of proof here? Who has to prove that something wrong has happened, or who has to prove that we haven't done anything wrong? If you see Article 14, if your fundamental right of equality has been hurt, the onus of proof is on you, the citizens, or the person whose fundamental right of of equality has been hurt. The Article 14 has been given to everyone, to the citizens and to the non-citizens. But who is going to prove? If you are going to go to the court and say that my Article 14 has been hurt, my Article 14 has been taken away or abridged, to prove that it has happened lies on you. The onus of proof lies on the person who is approaching the court. That happens in Article 14. But what happens in Article 19 and 21? It is the state who has to prove that the restrictions were reasonable. So if you approach court and say that my fundamental right of freedom, of right to reside and movement has been taken away, so it is the state who has to answer, and state who has to prove that it was taken away by the procedure established by law, which is reasonable. Means the restriction which has been imposed on the movement and on the residents were reasonable. It is the state who has to prove. Similarly, under Article 21 also, if you approach court and say my right to life and liberty has been taken away, so it is on the state to show that it was taken away by reasonable by justness and in a proper manner. If not, then either you will be compensated or you will be given justice in whichever way, shape and form the Supreme Court decides. So, the onus of proof under Article 19 and 21 lies on state, and under Article 14 lies on the person who is approaching the court. So, we were talking about rape, which is one of the most hated crime. It destroys the dignity of a woman to extents one cannot imagine. What's happening? Her life and liberty has been taken away. When we say life, it is dignified life. So, she does not feel in her own dignity to live after such an incident has happened with her. So, the interpretations of the Supreme Court after Menaka Gandhi case has been very, very wide and very liberal, and whatever has been expressed in the Supreme Court, it is not limited to the expressed version of the fundamental right, but has taken a huge mammoth form, and practically everything which is coming under life and personal liberty has been included under Article 21. Noise pollution. You must have seen DJs playing and everywhere at the night after 10 p.m. also. So, Supreme Court came up that if you have to provide dignified life to a person, he also have the right to sleep. For a proper sleep, you need a quiet and a calm environment that is disturbed by somebody else. You have the right to play songs, you have the freedom to play whichever song you like, but play it in a closed space where you live. You also have the right to celebrate, but that does not mean you celebrate in such a manner that it causes problem for the other person's life or causes problem for the other person's liberty. So, this noise pollution thing came up quite largely. If you see burning of crackers on Deepavali, what is that? You can celebrate, why not? But those crackers were banned in Delhi. Why? Because they are causing pollution. They are causing noise pollution, they are causing air pollution, and to an extent water pollution. So, the environment has been polluted, which then after a Deepavali in Delhi, what ends up happening is more and more people go to hospital, especially the older citizens, respected citizens, they have to go to hospital because of the breathing problems. So, such incidences have to be stopped. There is no stoppage on the celebration of Deepavali, but celebration of Deepavali has to be done in a manner that it should not cause public health problem. The burning of crackers were banned because of this reason in Delhi, because it already has the problem of pollution, especially in the winters. Environmental protection. Two very important elements have been introduced by Supreme Court in all its judgment and interpretations when it comes to the environmental protection. Polluter pays. And precautionary principle. They both are covered under the sustainability principle. So, what is sustainability principle? First thing, the intergenerational right, that you do not cause harm to the environment to such an extent that the next generation which is coming up finds it hard to reverse that they do not have the resources necessary for life. The developmental process should not go to such an extent that it causes harm to the environment in a manner that the next generation is not able to live properly, but is always involved in reversing the damages done to the environment by the previous generation. So, whatever development you are doing has to be sustainable. Sustainable means any sort of development which can go on for a longer period of time without hampering or causing any disability on the coming generation. as far as resources go, as far as their liberty to grow themselves to the optimum level goes. So that's what is sustainability principle, that if a case comes up to the Supreme Court where it has to decide whether one project would be sustainable or not, that it is causing irreversible harm to the environment and will not be sustainable, such a project must be shut down. Impact assessment reports have to be filed beforehand. The court decides in such matters whether the sustainability principle is followed or not. Then comes the polluter pays principle. The one who is polluting must pay for the damages he has done. Then comes the precautionary principle, that is mostly applied on the government, that they have to take precautions beforehand that sustainability in the environmental projects are maintained and the developmental work should not go to the extent that it causes irreversible damage to the environment. So these three principles are very important: the precautionary principle, the polluter pays principle, and the sustainability principle when it comes to the environmental protection. Then Vishaka guidelines, a woman who is working at a workplace needs protection, and if she goes to the workplace and has been harassed by people, her dignity snatched away from her, such a thing is not a good thing in a civilized society. So a civilized society must have some guidelines or some law to protect women at the workplace. And Vishaka guidelines are such guidelines which were directed by the Supreme Court in the Vishaka versus State of Rajasthan. Under Article 21, a woman can reach to the under Article 32, a woman can reach to the Supreme Court if she has been harassed in a workplace because her Article 21, the article which gives liberty to a woman to go and work at any place she wants, has been taken away. So Vishaka guidelines is one of the most important interpretation of the Supreme Court, direction of the Supreme Court in protection of equality in the society. If such guidelines does not exist, what will end up happening is the society will become unequal, that women will stop because of where she does not have the enough protection, they will stop going out of the house to work, and in such a situation what will end up happening is all the jobs will be taken over by men, and women, they will not be able to develop in such a way that they can sustain their life in a dignified manner. For such a thing to happen, that the equality which has to be maintained in the society, Vishaka guidelines are paramount. In this judgment, Supreme Court came up with a view that Article 14 is also included within this. These guidelines also maintain the right to equality in the society, that the man and the women are equal and equal protection has to be provided to them. Does not mean where, even if it is the workplace. Then comes the privacy. In the previous years, the right to privacy judgment, a 9 judges bench have came up with this judgment of right to privacy. This has changed the life for many people. Liberty also means you have the ability to express your gender in whichever way you want, and that is covered under Article 21. Under right to privacy, they have said is the inherent principle under Article 21, that if you have life and if you want to have a dignified life and you have the liberty, then the privacy is needed. Think about a situation where a person has been accused of something, but there is a media trial and reports and newses and false stories has been printed in the newspaper defaming that person, and then he is acquitted by the court saying that he has not committed such an act, but his image has been tarnished badly. Such a society shows the signs of uncivilized society. To maintain the civilization in a society, to maintain the personal liberty and dignified life of a person, it is important that the person have privacy. Even the accused who are convicted also have privacy, and their names are also not disclosed. They are disclosed to the extent that the person, when they come out of the jail, the people, the society must not harass them, must not discriminate against them just because of what they did in their life. They have already paid for it. So the privacy of the accused and the privacy of the victim has to be maintained. Not only of the victim and the accused, but also of the free people of this country. The privacy is paramount. Think about a situation where your phone has been tapped by government. What will happen? You have the privacy to speak in a personal room. If you are talking to your friend, you have all the right to speak whatever you want, and all the right to discuss, express your ideas, like whichever cricket team you like, whichever religion you want to criticize, whichever judgment you want to criticize, you can do anything. Think of a situation where your phone has been tapped by the government and has been released on internet. What will happen to your dignity? What will happen to your liberty? So it is important to have privacy in your life, and Article 21 protects your privacy. You can express your gender in whichever way you want. That's also a matter of your privacy. If you want to disclose it, do it. If you don't want to disclose it, don't do it. And nobody else can do it. That's why the huge data which has been taken by the government in several of the schemes, such as the Aadhaar scheme and the other schemes. What will happen if that data, which contains the personal biometric information of the people and also the other information of the people, has been leaked, or it has been sold, it has been given to someone else? That is why this privacy issue keeps coming in front of the court, that if government is taking the data, how are they protecting it? Even the telephone companies which has so much of the data, the banks who have so much of the information about your financial well-beings and about your financial bankruptcies, and also about so many other things, about your address, about your gender, about so many things, it can be made public, and that may hurt your image. You can be defamed. So to protect your privacy, which is the inherent part of liberty, right to privacy is included in Article 21. This has not been expressed in the Constitution, but the interpretation of the Supreme Court says so. Same is your reputation. Think about it. If your reputation has been taken away, your life has been taken away. And reputation can be taken away by so many things. So Supreme Court tries to protect your reputation. So Article 21 has turned out to be one of the major provider of fundamental right to the citizens of the country, one of the major provider of dignity, one of the major provider of personal liberty to the citizen of this country. And this has happened when Article 21 was reinterpreted in the Maneka Gandhi case. You have so many rights now. You can enjoy freedoms to extents which our previous generations have not thought about, especially when the country was under the British yoke. But now, because of the efforts and the activisms made by court, and also the changes brought in the society because of the modernization, such judgments are welcome and they are coming. So what we have studied here is the basic overview of Article 21, how the procedure established by law was reinterpreted to include the due process also, and how the substantive and the procedural law both has to be reasonable, just and proper. Then we came upon the four important aspects which is contained in right to life and personal liberty, life, liberty, law and procedure, and then we have seen what changes the Menaka Gandhi judgment has brought to the life of the people and the constitutional life of the country. I hope you enjoyed this video, and if you have any question you can post in the comment section. Thank you very much.